Court of Appeals is now in session.
Good morning, everybody. Welcome to Division 1 of the Court of Appeals. We have two oral arguments scheduled at 9 o'clock and then a third one scheduled at 10. I see counsel are set up for the first case, which is People v. Genrich. Am I pronouncing the defendant's name correctly?
I think it's Genrich.
Genrich? Okay. Well, I guess I was incorrect in either of the two alternatives I was contemplating. But thank you for clarifying that. The second case is Willington Savings Fund versus Michalski, or as personal representative of the estate of Haney. Are counsel here for that case?
I am. I'm not sure about my opposing counsel.
Okay, well, we'll hear argument second in that case. Hopefully your opposing counsel will show up shortly. Let me just briefly review our procedures. As you know, we have 15 minutes for each side for oral argument. The judges have read the briefs and have had a chance to review the record, so you may wish to focus your oral argument on the legal issues rather than the facts, but of course how you conduct your oral argument is up to you. Excuse me. You should know that we're live streaming the oral arguments. They're also archived later. So if you have any confidential information, you may wish to be careful as to how you refer to it during the oral argument. There's a toggle switch that you can use on the podium to raise or lower it at your convenience. I neglected to say for the 15 minutes we have our traditional color-coded timers that are green when you start and amber when you have 5 minutes left and red when your time is up. But there's also a digital timer so you can plan your time accordingly. And I would ask everybody in the courtroom, if you have a cell phone, to make sure that it's turned off so it doesn't interrupt us inadvertently during the oral argument. And with that having said, we're ready to begin the oral argument in People v. Genrich.
Good morning. My name is Beth Krulowicz, and I'm here with my colleagues Chris Fabricant from the Innocence Project and Corey Brady and Brian Legal, who are with the firm of Weil Gottschall, who are working on this case along with me. And I would like to reserve 5 minutes for rebuttal.
Very well. I'll try and indicate that to you when we get to that point.
Thank you. Your Honors, we are here on an exceedingly narrow issue. The only question for this court to decide is whether our client, Jimmy Genrich, is entitled to a hearing on the motion for new trial that he filed in the district court. That's it. That's all we're asking this court for, is to order that Mr. Genrich be provided an opportunity to present evidence in support of his motion.
What do you think the issues will be if we do that? What will the issues be in the district court? What does the district court have to decide?
The district court will have to decide, number one, whether the opinions that were given originally in 1993, which involved individualization, which is the concept. This toolmark examiner was permitted to testify and instructed the jury that every tool in the world is unique. So in other words, a mass-produced common household wire cutter has unique characteristics that can ultimately be passed on to an object that it is used on and later identified to the exclusion of every other tool in the world. So the primary issue will be whether that opinion, given what we now know about the lack of science supporting it, whether that would be permitted. That would be the primary issue.
Wouldn't the court also have to decide whether, absent that evidence, it's likely there would have been an acquittal?
I think the court would, that would go to the materiality of the evidence, and I think that That issue of whether or not there would be an acquittal, I think, is it would be difficult to dispute that without that evidence, without that opinion, that there would be an acquittal, given that the prosecutor and the judge on the record during the trial, and just to give you a little context, during the trial in 1993, the defense lawyers filed a motion to exclude this toolmark examiner based on discovery violations. He didn't provide all of the discovery that the trial court had ordered. And in the consideration of that motion, the prosecutor and the judge both acknowledged on the record that excluding the testimony of this toolmark examiner would be tantamount to dismissal.
What would you expect the prosecutor to say? I mean, Judge, I got lots of evidence, so I don't really care whether you admit this evidence. I mean, it just seems to me that's the type of statement made in a trial court that really has almost no bearing on the ultimate very important question here, which is whether or not acquittal would have been likely. I understand your argument, but it doesn't seem to me it has much weight.
Well, there wasn't any other evidence, Your Honor, that connected my client to the building of these bombs. That was it. There might have been some evidence that he was kind of an unusual character and some other things, for sure, that gave the police reason to look at him. But there were 30-some other alternate suspects that they were also looking at. And given that the toolmark evidence was so significant that there was nothing else that connected him to the actual building of these bombs.
Does anything in the new evidence suggest that it's affirmatively probative of his actual innocence?
That it's affirmatively probative of his actual innocence?
Yeah.
Well, I mean, simply the fact that the new evidence, which is, I mean, let's think about this. We've got an expert who was permitted to tell the jury that to the exclusion of every other tool in the world, that the wire cutter taken from my client's toolbox made a mark on a wire on the bomb. Now, we would be able to show now, given what science now knows, that there is absolutely no science. It has not been scientifically validated. It has not been sufficiently studied. There is no science to support that opinion.
There's no science to dispute it yet either, is there?
Well, but that's not the standard, Your Honor. I mean, really, the trial court has to act as the gatekeeper in terms of what evidence to allow in and to allow out. And, in Shrek, I would quote to you one of the statements that our Supreme Court made in Shrek, and when adopting 702 as the standard, which was not the standard at the time of the trial, but in adopting 702 as the standard, the trial court in Shrek was anticipating concerns that 702 would be a liberal enough standard that it might allow in evidence that wasn't reliable. And in that regard, the Shrek court said, "We hold that under the standard, the focus of a trial court's inquiry should be on the reliability and relevance of the scientific evidence, and that such an inquiry requires determination as to the reliability of the scientific principles."
So are you arguing that Shrek, which wasn't the standard in 1993, should have been the standard the court applied? In other words, are you arguing that Shrek applies retroactively to cases that were not still pending on direct review?
No, what I'm arguing is that the progress of science has marched forward. And we now know what we didn't know in 1993, which is that these opinions of 100% certainty, opinions of individualization, that's the theory that this expert testified to. And individualization means that of the millions and millions of wire cutters in the world, that he could say that this one wire cutter absolutely cut the wire that was left at the crime scene. So that theory, there is no scientific evidence to support it. And we know that now, and we didn't know that in 1993, but we know that now because of the work of the National Academy of Sciences, and we provided an affidavit from someone who sat on that committee and heard that evidence.
Ms. Krulwich, is there any testimony given by O'Neill that would pass muster today? In other words, you seem to present it as an all or nothing deal. You say that this business about those being the only tools in the world that could have created those marks, that just doesn't have any scientific support. But he testified for like 5 days, I think. At least that's what I was going through when I was trying to read all of it. Is there anything that he said that would be admissible?
Well, I think that that would be a determination for the district court to decide after we have an evidentiary hearing. You know, our position is that the opinions, the conclusions that he gave, and really, while he did, his testimony was lengthy and it was interrupted, and I think that's why it went on for days and days. His opinions, though, were those individualization opinions that identified the wire cutter to the exclusion of all other wire cutters in the world. To the extent that he would be permitted to testify to anything short of that, that could only be decided after an evidentiary hearing, which is all we're asking for.
And that would bear on the question of whether or not an acquittal would have been likely. Am I right? In other words, if some of his testimony was admissible, but not all of it, the trial court would have to take that into account in making the determination of whether or not an acquittal would have been likely.
Well, I think if we're given an opportunity to have an evidentiary hearing, I think what the trial court would be required to look at is, would O'Neill's opinions, if he's permitted to testify at all, but not allowed to give the opinions of individualization, how his testimony would stand up when we bring in, you know, we have one affidavit that was already submitted from an esteemed forensic scientist with 40 years of experience. An amicus brief was filed where we have 36 signatories, 5 of which were also on the NAS committee, any one of which would be willing to come in and testify about the lack of science supporting tool mark identification. And I do want to make a distinction here as well, Judge. You know, tool mark is a big category. Now, the area of firearms and ballistics is a subset of tool mark, but the case that we cited to the district court that the district court didn't even mention, the Smallwood case, is a case out of a federal district court in Kentucky. And in that case, the court talked a lot about the distinctions between the reliability of firearms analysis and the reliability of tool mark analysis, of a handheld mass-produced tool. And in that case, the court in Smallwood stated that there are important distinctions between tool marks and firearms, and these distinctions make tool mark identification particularly unreliable. And that's a case that was cited to the district court in this case, and the district court completely ignored.
Counsel, if I may, I'm going to state something, and I'm going to ask you to agree or disagree with it. Individual patterns from manufacture or wear might in some cases be distinctive enough to suggest one particular source. You agree or disagree?
That it might be? I guess I could go with it might be.
That statement comes straight from the NAS report, and it's about tool mark evidence.
Yeah.
Doesn't that suggest that Mr. O'Neill's testimony might have actually been accurate?
I don't think so. Saying that there may be some characteristics that might be sufficient to compare or to identify, falls far short from saying to a jury that I can identify this. He stated this as a scientific fact. He left no room for any qualification that he could be wrong. He stated to 100% certainty that he identified this wire cutter to the exclusion of every other wire cutter in the world. That's a very different opinion than what you talked about just now.
Ms. Kruwich, you have less than 5 minutes left.
Okay, I will reserve the remainder of my time. Thank you.
May it please the court, I'm Matthew Holman, and I represent the people in this matter. The overarching issue in this case is whether the trial court properly denied the 35C motion that was before it. And I think we're all familiar with the standards the court applies there, which is the motion must set forth facts that, if true, would entitle the defendant to relief. The motion may be summarily denied if the motion, the files, and the trial court records clearly establish that the defendant is not entitled to relief, and barren conclusory claims cannot support a hearing.
Are you suggesting their claims are bare and conclusory?
I think to some degree they are. I think my reading of the motion itself is part of its conclusory is that there hasn't been any scientific evidence or studies done to determine scientifically, so through the scientific process, whether this evidence is reliable or is not reliable. And in fact, their expert, Dr. Siegel, says we don't know whether this is reliable because it hasn't been subjected to these scientific methods.
But isn't that the same thing as saying it is unreliable when you apply 702? I mean, the proponent's burden is to show that it is reliable. It's not the opponent's burden to show that it isn't. So I get lost when you say that.
All right.
It seems to me the showing made in the motion is that science, or at least a lot of scientists say, there is no way that anyone in the world can reliably say that this tool, to the exclusion of every other tool in the world, created this mark. I mean, that seemed to be what the scientists say.
Well,
So I'm really not understanding why you're saying it's conclusory.
all right, let me try to clarify. First of all, again, we're focusing on the motion that was filed in Dr. Siegel's statements, which are, we don't know as scientists whether this is reliable or valid because, in our opinion, unless you apply scientific methods of blind studies and scientific research, we don't feel that that can be determined. On the other hand, Rule 702 and Schreck clearly say that experience-based expert opinions, such as Mr. O'Neill's here, is admissible at trial, and that you may use an experience-based analysis, which here would be observation and repeated experience, and that's what he relies on his opinions.
But he didn't look at every tool in the world. I mean, I think you'll concede that.
I do concede that, and going to that point, he makes clear that the basis for his opinion is two things. One is over 20 years of experience serving as an editor of a tool-marked journal and having never heard ever of two tools leaving identical marks. And also his one test of taking two tools fresh off the assembly line and evaluating them and finding that they're clearly distinguishable, that they may share some similarities, but they are clearly distinguishable from one another. So he's very candid about how he's formed his opinion after testifying more than 400 times in cases, more than 20 years of experience studying and training others and being trained on tools as the basis of his opinion. He does not say, there are studies that show that every tool in the world is not identical. He didn't say that. In fact, one of the things I point out in the brief is that the type of evidence they're talking about here was put on by the defense expert in the trial below, so this is not new evidence. Dr. Don Searles testified to the very things that they're talking about now. He said, we would need a large database with millions of tools to determine whether two tools are actually not identical. And without that, that can't be scientifically proven. And he said there may be a danger of bias or he called it the placebo effect because of the method that is used is very subjective and the examiner knows the tool that's to be used or to be examined is the suspect tool. And so he goes through that, all those things that they're talking about here. This is not new evidence. There may be a new report published years later, but that evidence is not new.
Can I shift gears on you just
Sure.
a moment? I want to talk about the other evidence because, not surprisingly, counsel for the defendant downplays the other evidence that was presented to the jury. Can you talk a little bit about the other evidence and whether you agree that absent the tool mark evidence, as I understand their argument, it's like they're saying the court would have been required to grant a directed verdict. Do you agree with that?
I would not agree with that. And I just as a side note, when you were talking about the comments made during the discovery issue where the prosecutor says, you know, this would virtually be a dismissal of our case if we didn't have this evidence, I think your point was that that's really not the same as saying there isn't sufficient evidence to go forward. So I would discount that comment and the court's comment, because I think that's in the context of a ruling where they're supposed to determine the least severe sanction for a discovery violation that's appropriate versus something that might hamper the case quite a bit. But going back to your question, and there's a lot of detail in my brief on this, there was quite a considerable bit of evidence that connected the defendant to the pipe bombings. He was seen at the scene of the Valentine's Day bombing at the, I can't remember the name of the facility, but a convention center, repeatedly going there and seen on the day looking into the parking garage where the pipe bomb was placed. His location to both several of the bombings and a surplus store which carried most of the types of things that, or maybe it was all the things that were used to make these bombs, was near his house or his apartment. He was seen there in the pipe department and then in the gun department later. He admitted to the police that he had reviewed the anarchist cookbook. His statements to a detective who he was talking to seemed to indicate he knew that his tools could be used to make the bombs, and those are the ones the police would probably take from his apartment. Perhaps the most sort of compelling evidence about his intent and motive were I would call it a diary he kept on the back of envelopes. And if you look at the dates of several of those comments, they are not on the day of the bombings, but they're contemporaneous with the bombings. And one of the things he mentions is, I don't have a girlfriend, Valentine's Day is coming. And another one he says, don't blame me if I kill someone tonight or today or whatever it is.
But Mr. Holman, how do those statements about possibly killing someone because of an inability to get along with women or find a girlfriend have to relate specifically to a pipe bombing of nobody in particular?
Well, I think you can have random acts that are motivated by unique frustration. I think one of the bombs being placed on Valentine's Day, which he connects with having a romantic relationship, is a strong connection between those statements and that bombing. So I think even if they're random, people act out randomly to express anger. I think there are multiple crimes that seemingly have nothing to do with the people who are harmed, but the motivation may be specific frustration. So.
Mr. Holman, if it's true that there is absolutely no scientific basis for the opinion given by O'Neill that these are the only tools in the world that could have created the marks on the wire, if that's true, assume that's true for a second, is there other testimony that was given by O'Neill that would nevertheless pass muster and be admissible?
I'm going to say yes, but I know there's a lot, and I haven't reviewed it all, and I know he was recalled for different purposes throughout. I think, I'm sure that there's quite a bit of it. I mean, I would say that my sense is their best argument, which I disagree with, is that his statement of certitude is too extreme, and somehow that's prejudicial here. I would disagree with that, but I think a lot of his testimony would come in. And also, we have other experts who connect the bombs to one another. There's an expert who testifies that these bombs were all made by the same person because they're built similarly and they don't have a safety switch, and other expert opinions on that point.
On the issue of, as you said, that you phrased it, what you see as their strongest argument, if in fact they have alleged with factual support that the statement of certitude on the individualization is not proper, aren't they entitled to an evidentiary hearing to see if the trial court determines whether it was so not proper that it warrants a new trial? Isn't that what the evidentiary hearing they're asking for would be all about?
No, I didn't say it was their strongest, it was their best argument, but no, that's a joke. But anyway, which is probably the same thing. No, and I don't think so, and the reason is the standard for the trial court that reviews this is the trial court's supposed to review the motion, the files, and the record and determine whether the defendant is entitled to relief, and that's what the court did here. And 2 points, I would say that statement that he said it with 100% certitude is conclusory, And then if you look at the record, what he said was, yes, I am certain that this tool made it to the exclusion of all others, but he explains the basis for that, which are his years of experience and this one test that he did. The defense puts on the exact same evidence that they've put on, that they want to put on now, albeit with new experts and new reports about this is not good enough under the scientific analysis, and the jury convicts under that. I don't think there's enough there in that claim that he said it with some sort of 100% certitude. I think he qualifies his own opinion. He also admits that there are two other prosecution experts whom he respects who testified that 2 out of 3 of his findings were incorrect. So I think the jury's well aware that there are limits and qualifications to this based both on his own testimony describing his own knowledge, the other experts, and the defense's own scientific expert who says the very same things they want to bring in now. So I think...
They didn't say they were incorrect. They said they couldn't come to the same conclusion. I mean,
That's right.
The 2 other experts didn't say that O'Neill was wrong. They just said, I can't reach as to those 2 marks. I can't reach the same conclusion at least with the kind of certitude that O'Neill did.
Well, I think what they said...
Isn't that what happened?
Well, what they said was that their findings were inconclusive as to whether there was a match. So they disagreed that they could find a match, which I think is the same thing as saying they felt that he was incorrect in his analysis.
But before your time runs out, Judge Tao used the words actual innocence. Does the distinction between actual innocence and just the inability of the state to prove guilt beyond a reasonable doubt, does that distinction have any play in this case?
I think it does. If you look at the case law, I think it's Farrar for newly discovered evidence, it says that the defendant's evidence itself has to have here, I'll look at the language, affirmatively be probative of defendant's innocence. And I would argue that it is not. Their argument is, we don't know whether this is reliable or valid because, in our opinion, scientists would have to do this, we don't believe in experience-based analysis, which is well accepted by the courts here and under Rule 702. I think it's different to say that they could challenge it now and it might not have been admissible at trial if they'd only had this report is not the same as saying this opinion proves that he's innocent. So I think that's a distinction.
Mr. Holman, if there were an evidentiary hearing in this case, is it possible that the trial court could conclude that Mr. O'Neill or some equivalent expert could no longer testify as an expert because his testimony was no longer reliable?
Well, first of all, the trial court already assessed his testimony and found that based on the opinions that they put forward in their motion and with their affidavit, that his testimony would still be admissible. So that decision has been made unless this court finds based on those facts that that's inadequate. That decision's already been made. I think
including the testimony that this is the only tool in the world to create that mark? I mean, do you read the trial judge's ruling as saying that would be okay, or that is okay?
The trial court said that his testimony would be admissible and that this evidence that they were offering would only go to the weight and not the admissibility of it. The trial court also disagreed that the NAS report undermined or disputed or disproved his opinion. And I think the point is the one I've been making, which is to simply say we can question this because we think it should have been evaluated one way and not the other is not the same thing as saying we have studies that show this is in fact unreliable. And again, I would just finish by saying Mr. O'Neill did not say that this was 100% certain. Absolutely, he qualified the basis of his opinion. It was subject to vigorous cross-examination and expert testimony to the contrary. May I finish?
Yes, you may.
And that's specifically what Schreck talks about as being sort of the way that this sort of evidence is tested by vigorous cross-examination and expert testimony contradicting it. So I think those standards have been met. Thank you very much for your time.
Thank you, Mr. Holman.
Lots cover here. I'll do my best to do it in 4 minutes and 38 seconds. Number one, I think the questions from this court really highlight very well the need for a hearing on this. The trial court, the district court in this case, the primary error that the district court made was he did not presume, as Colorado law requires, the truth of the facts that were asserted in our motion. He didn't do that, and that's what Colorado law requires.
What facts did he not presume the truth of?
The fact that the scientific community now, across the board, there is a consensus in the scientific community that the testimony as to individualization, the ability to identify a tool as being the only source of a mark later on, that is not supported by science.
But is that an assertion that just because it's not supported by science is one thing, but is it an assertion that it is wrong?
Well,
That his opinion was incorrect?
It's an assertion that, based on what we know now and the law as it is now, that those opinions would not be admissible under Schreck and Ruyball. You know, our Supreme Court has just came out with a very recent announcement on the trial court as a gatekeeper and what the trial court needs to do, and that is very relevant here. So the fact that an expert was permitted to testify to a scientific certainty, and now we know that that opinion was not supported by science, that's a fact that needed to be presumed true, and a hearing would then allow a district court to decide whether they agreed with us, you know, at all, or you know, in part.
But aren't there different considerations? I mean, we're not here on a direct appeal of the conviction, okay?
Right.
And that would be a rather different proceeding. We're here, what, 25 years later? Isn't the fact that so much time has elapsed mean that we have to look at this a little bit differently, the way I think Judge Tao may be suggesting, than if this was on direct appeal? After all, on direct appeal, a division of this court said everything was fine, right?
That's true, but on direct appeal, even at the time of the direct appeal, the evidence that we have brought forth today didn't exist. So we really are dealing with newly discovered evidence. And I'm going to cite you to a case that Judge Taubman actually cited with approval in the Bonin case, which dealt with a similar issue, and that is State versus Ben, which is from New Jersey. But in that case, the court in New Jersey made this statement, and I think it's very appropriate here. And it says that science moves inexorably forward, and hypotheses or methodologies once considered sacrosanct are modified or discarded. The judicial system, with its search for the closest approximation to the truth, must accommodate this ever-changing scientific landscape. And that's what we're asking for here, is for the court to give us an opportunity to present evidence so that we can convince the district court that there has been a change in the science, and that this change in the science reveals that our client was convicted on evidence that was at best misleading and at worst absolutely false. And I do want to point out one thing. I know the court seems concerned about what other evidence there might have been. One fact that kind of gets lost in all this is that the prosecution's theory was that one person did all these bombings. And in 1989, the first bomb that was discovered in 1989, a time when our client was living in Phoenix, Arizona, 600 miles away from Grand Junction. And despite all the best efforts of the FBI and the Grand Junction police, they never found anything that suggested that he came to Grand Junction during that time. So there is plenty of room for doubt in this case. And again, the standard is proof beyond a reasonable doubt. And if we were allowed to go to trial on a new trial and present what science now knows, then I think that it is very likely that Mr. Gingrich would be acquitted.
Thank you very much, Ms. Kulwich. Thank you again, Mr. Holman. We very much appreciate your arguments. Ms. Krulwich, we appreciate your colleagues coming from New York to attend the oral argument. The case will stand submitted, and a written opinion will issue in due course. When counsel have taken up their belongings from the table, then we'll be ready to hear the oral argument in Wilmington Savings Fund v. Haney. Mr. Fielder, is that correct? You were not in the courtroom when I reviewed our procedures. Are you familiar with our procedures for oral argument? Okay, in that event, I won't repeat them, and when you're ready, we can go ahead and begin with the oral argument. I would again say if there's anybody new who's entered the courtroom, to make sure that if you have a cell phone, that it's turned off so it doesn't inadvertently interrupt us. Okay, Mr. Fielder, whenever you're ready.
Yes, thank you very much, Your Honor. Thank you, Your Honors. When we're in the area of non-judicial foreclosure law, we deal in presumptions. There's a presumption that the listed parties are persons. There's a presumption that the deed of trust is valid. There's a presumption that the promissory note is enforceable. There's a presumption of default, quite frankly, all rebuttable. And in this situation, Federal National Mortgage Association, otherwise known as Fannie Mae, filed a Rule 120 against my client, Ms. Haney, who's now deceased. And of course, she had a statutory right to file a response, which we did. We didn't believe that Fannie Mae was the real party in interest, and we litigated that. And we lost the Rule 120 hearing. And then the day of the sale, there was a transfer, there was an assignment of the note to the party, Wilmington Savings Fund Society, as trustee for Carlsbad Funding Mortgage Trust. However, as I've outlined in my brief, there's another presumption that's created. And under 3838-101-8C, if the person that the evidence of debt is being assigned to plans on proceeding as a qualified holder, then they must follow the statute.
Mr. Fielder, do you
Yes.
agree that even though the statutory procedure evidently was not followed, that Wilmington would have qualified as a qualified holder under the statute?
No, I don't, because in the end, I was still litigating that issue as sort of an issue that was connected to Fannie Mae, whether they had even the authority to transfer that, which they did not hold. And so there was still an issue with regard to that.
Well, that's a different issue, isn't it? I mean, Wilmington, as I understand it, is a federally chartered bank or savings association. Doesn't that by itself render them under the statute a qualified holder?
Well, they weren't really acting as a bank in this particular situation. They were acting as a trustee. But even if they're otherwise a qualified holder, meaning that the checkbox as to what they are could be fulfilled, there's the second part, which is their choice of either filing the original with the public trustee, which is rarely done, filing a simple certificate of an attorney, which is the preferred method, or posting a bond. So in that regard, in order for them to make that credit bid, they had to submit something. They could have paid cash, but why would they do that when
So
they were the alleged holder?
What's the end game here? In other words, what do you ultimately want out of this litigation?
A day in court, really. The Rule 120 is not a day in court. It's non-judicial. I couldn't appeal. I went to the federal court. They did not accept the case for lack of subject matter jurisdiction. They said it was barred under Rooker-Feldman. So I could have filed an offensive Rule 105 against Wilmington, which would have come. My client stayed in the possession. But once the eviction was filed, and this was before the federal case had been dismissed, so I was still hoping for relief in the federal court. Once the eviction was filed, I filed my Rule 105. That's the correct procedure. That's the jurisdiction of the court, the judicial jurisdiction where we could have settled these issues. So with that day in court, I understand that I may not have gotten discovery. It could have been handled by the pleadings, but in the end, Ms. Haney would have gotten her day in court, which we never had. After all this litigation, I've never had a judicial hearing with regard to my argument.
But isn't it undisputed that Ms. Haney defaulted under the note? I'm just trying to figure out what we are doing here and why we are spending these enormous resources when the end game seems to me, based upon your brief, is ultimately someday, and if you have your way, it won't be soon, there will be a foreclosure, title will be lost, the bank will own the property. What exactly are we doing here?
Well, my client has a right to due process because, and I know that she waived many of those rights by signing the deed of trust, but it wasn't her note. It was one of the other co-owners of the property, and even that could be in dispute. And so in that regard, the note may have been in default, but she wasn't, because she wasn't required to pay under the terms of the note. The issue would have been the deed of trust and the enforceability of the deed of trust. And so I think that Ms. Haney had arguments, and they weren't just arguments, but she had a right to certain relief, and that relief just was never forthcoming.
Did you ever challenge the validity of the deed of trust?
That was one of the declaratory judgment issues that I'd filed in the federal court, because I asked for federal jurisdiction based upon the parties, one of them being Fannie Mae, another one being Bank of America. But I also asked for declaratory relief.
What
and in that
argument,
regard.
what argument did you make that the deed of trust was invalid?
Well, my argument is that Mr. Finstamaker fraudulently induced my client to enter into this deed of trust by overcoming her will on a number of different occasions, because he would just refinance the note, and each time the note got bigger. But that was the ultimate case. I mean, in the end, Mr. Finstamaker would have had to been brought in on the Rule 105 and added as a party. For me, it was essential to try to get the sale set aside so that I could have a full arbitration, I could have a full litigation of the rights pursuant to Rule 105, because she did have rights and she had a claim to that property. So, and Your Honor, I'm being very respectful in the sense that obviously the country went through a foreclosure crisis involving some of these very parties like Countrywide, and whether it's properly placed in the trust, I realize that's when everybody's eyes roll back in their head, because those are branches way up and around the tree. But at its very essence, my client was the owner. She had a deed, she was in possession, and she had a right to a hearing. She had a right to determine who the real party in interest was. And that was never fully adjudicated. And so we came to the court in honor. Everything I've ever filed has been in honor. I've made some mistakes, but I've always been in honor. And I just
Mr. Fielder, excuse me for interrupting, but wasn't the question of the real party in interest addressed in the Rule 120 hearing?
Yes, it was. We fought that vehemently, and I lost, but I didn't have a right to appeal. So in that sense, there wasn't a judicial finding that they were the real party in interest. So I went to the federal court because it's my argument that Fannie Mae is a quasi federal agency, but I was rejected under Rooker-Feldman, and that's essentially, I think that the district court believed that this was a final foreclosure, that the foreclosure was over, you had your chance, it was res judicata, and that's really the focus of my argument in terms of the magistrate's error, which I claim, is that she believed that it was a final foreclosure. She didn't think I had any rights to assert ownership or to challenge the real party in interest or whatever the case may have been.
Is there some point when the right to challenge the foreclosure ends And I'm not talking about claims of damages now, I'm talking about claims relating to title to the property. Is there some point in time, some event that occurs that legally says, you're done? You can no longer challenge who owns this property as a result of the foreclosure?
Yes, and I think that's through the relatively simple procedure of Rule 105. And that's where I'm saying I wouldn't expect 2 years of litigation and interrogatories. I would expect literally an hour or 2 hour long hearing on the Rule
No,
105.
but that's not my question.
And that would be the end.
No, my question is, can the foreclosed party sit back and wait 3 years or 5 years or 5 years and 11 months and then come in and say, this foreclosure that happened 5 years ago or 3 years ago was invalid, so I want the property back?
Well, I think there's been some recent developments in that, in terms of the statute of limitations being a long time for the holder of the note to the maturity of the note. But if a foreclosure happened, then, like I said, you could either file something within, I think, a 2-year statute of limitations to challenge it. Because if they get title and you're objecting to someone's title, then you have 2 years to challenge it. But if they move for eviction before you get your challenge ready, then you have to file your counterclaim or lose them. So I think that there is a limit of 2 years to challenge title. And title was, although I say it's a void title, title was issued in the public trustee cell. Could I reserve a couple of minutes for it?
You may certainly do that, Mr. Fielder. You have just over 5 minutes.
Appreciate it very much, and thank you, counsel.
May it please the court, my name is Kendra Beckwith, attorney registration number 40154, and I, along with my co-counsel John Sandberg, represent the appellee in this case. This is an appeal structured around a procedural technical deficiency that caused no harm to appellant. That technical deficiency, which is in effect the omission of a federal savings bank to file a notice stating the obvious, provides no basis for reversal here. An appellant is using it as a method to create an issue as to ownership, and to your question, Judge Berger, what's the end game? Delay possession as long as possible. No such issue exists
What about
here.
his argument? If I understand him correctly, he's saying it goes beyond the technical failure to file this statement that the statute authorizes, the qualified holder statement. He's saying there was a prior issue, a more important issue, that we don't even know that the people that foreclosed this were the real party in interest. What about that?
So that issue was decided after 2 days of hearing at the Rule 120 hearing.
But,
But-
Ms. Beckwith, isn't it true that under the Rule 120 procedure, that decision could not be appealed in the 120 proceeding?
It could not be appealed, so it's not final for purposes of appeal, but I don't think the court can ignore the fact that those 2 days of evidence occurred.
But
And I'm sorry, Your Honor.
Excuse me for interrupting, but if the Rule 120 proceeding could not be appealed, then does it have any issue or claim preclusion effect on future determination of that issue?
It doesn't have any claim preclusion effect, but I think what the district court did here was look not only at the claim preclusion analysis, but also looked at the Webermeyer case. And what the Webermeyer case says is that if you come on a 105 hearing, you have to be able to substantiate title based on the strength of your own title, not on the deficiencies of somebody else. And if you look at, it's the January 31st transcript between pages 15 and 16, what the district court really seems to be saying is exactly what Judge Berger articulated, which is you're not saying you were improperly foreclosed upon. What you're saying is that there was a procedural deficiency in the process. So you don't have title, it's the procedural deficiency.
But if Wilmington wasn't the real party in interest, that's a little more than a procedural problem, isn't it? I mean, if you're not the real party in interest, you have no right to either foreclose or to bring a Rule 120. seems to be more than a procedural problem.
Well, the issue with the 120 was never whether Wilmington was the real party in interest. The concern was whether Fannie Mae could be the real party in interest because it didn't present evidence of the original debt. Now, Fannie Mae, as a indisputably qualified holder, was not required to provide the original evidence of debt under 3838 101 1B11. So the standing issue there was resolved. The issue that the counterclaim, to the extent it was pled at all, now this counterclaim has morphed as the proceedings have grown longer, but to the extent their counterclaim even asserts that Wilmington didn't have standing, it has only to do with the failure to file either a qualified holder certificate or a evidence of original debt. Now, I agree, Judge Berger, that it is very clear from the record that Wilmington is a qualified holder. And as such, the only thing it would have needed to do, apart from what was done here, was file a piece of paper that had an attorney's signature and a statutory citation.
So, Ms. Beckwith, as I understand it, Mr. Fielder's argument is that based on 3838-101-8C, that the statute uses the word shall, and so those procedures were required to be followed and were not. Is my understanding correct about that?
That is correct. He does state that the statute, that 1018C does say shall. However, I think if you look at the substantial compliance body of jurisprudence that's come out of this court and the Supreme Court, that provision is effectively nothing more than a notice provision. The filing of a qualified holder statement doesn't provide any additional security. It doesn't provide anything different than simply notice to the borrower that here's where your loan is going now so that you know that this person does in fact have the right to foreclose on you. Well, that information was provided in the assignment and the notice of transfer. The only part that wasn't included on that document was, again, the statutory cite and a signature from Wilmington's attorney. Now, under the substantial compliance jurisprudence, what we do know is we don't elevate form over substance. You look at the consequences for noncompliance, and you don't force strict compliance to an absurd result. And quite frankly, that's what reversing or allowing a 105 claim on this theory would be. It would be reversing it on a technicality that, first of all, caused no harm to appellant. At all times, because Fannie Mae was a qualified holder and had assigned it, the indemnity that would have been afforded to appellant was always there.
Ms. Beckwith, let me shift gears on you for a minute. I want to talk about the FED trial, because it's one of the strangest trials I've ever had the opportunity to read a transcript of. There wasn't any evidence presented, no witnesses testified, and yet, at the end of this so-called trial, the district court made findings of fact, conclusions of law, and entered a judgment. Is that a trial?
I believe it is under these circumstances because the judge looked at the evidence that was already in the record, and there is no requirement in an FED proceeding that additional evidence be called.
But there wasn't even any evidence tendered. There was no evidence admitted. I mean, at a trial, a court admits evidence and then based upon that evidence decides the case. As I read the transcript of this trial, there never was any evidence admitted.
There is substantial evidence supporting the claim for possession. Was it admitted? I think the judge effectively admits it by saying, look, here's the evidence I'm looking at. And it's on pages 24 through 33 of the transcript where the judge goes through, here's all of the evidence I'm looking at. It's attached to the complaint. Here is where I'm looking at it. So is it formally admitted? I would say yes, because it's in the record, the judge is looking at it. Opposing counsel would have been well apprised of what it is, could have objected, could have made an evidentiary objection, didn't. All of that evidence is still there. Whether or not it's admitted formally through the hearing, I don't think is relevant for purposes of the possession.
Counsel,
issue.
I recall Mr. Fielder objecting to those documents, I believe his phrase was, on the record. Did he not?
If he may have, so I will correct myself, but
And I guess what I'm concerned about that Judge Berger has identified is we have a long-standing practice and body of jurisprudence that says just because you attach it to a pleading doesn't make it evidence. How does this trial comport with that long-standing rule?
Because I think the fact that the evidence was still there does allow, the fact that he still could have, that he did, excuse me, object to it, that there was still an opportunity to provide counter evidence, does effectively make that error, if it is error, harmless, because he was still given the opportunity to rebut it, and he was still aware of it.
But I think, as I understand it, Ms. Beckwith, part of Mr. Fielder's contention is that he was not afforded the opportunity to present evidence in behalf of his client. Do you disagree or agree with that?
I do disagree. He had full opportunity. So at the FED hearing, there are two separate issues. There's the 105 hearing, or the 105 issue that gets addressed at the beginning of the hearing, and then there is the rule, or the FED action that gets addressed at the second part of the hearing. He had every opportunity to be heard on the 105 hearing, and the theory that he didn't have a day in court is rebutted by the record that clearly sets forth that he was given ample opportunity to argue his case, both in the concept of the merits of his counterclaim at pages 7 through 13 of the January 31st transcript, the recusal of the 17 through the 18, page 17 through 18, and page 26 through 32 show him adequately defending his 105 counterclaim. As to the Rule 120, he was given the opportunity to present evidence to rebut it, or on the FED, was given that opportunity. That opportunity was there at the hearing. So he was given an opportunity on both fronts to defend his client's claims. If this court has no further questions, then I would respectfully ask that the order of possession be affirmed and that my client be awarded its attorney's fees.
I do have one other question, sorry. I want to ask you the same question I asked your opponent. Is there some time or some event that cuts off the ability of the foreclosed party to challenge title that changed hands as a result of the foreclosure?
I think this case probably demonstrates the limits of when that ends. I think you certainly do, I agree, have 2 years to challenge title once a title has vested, but I think the procedural mechanism that Ms. Haney used here was proper to bring the 105 claim. I think eventually when that process ends is after the possession hearing. Once you've had the opportunity to raise that issue, then I think you accept the fact that the deed has transferred and the foreclosure proceedings are over.
So, Ms. Beckwith, not to prolong this, but isn't what you just said inconsistent with your statements in your brief that Mr. Fielder or Ms. Haney had a full opportunity in the Rule 120 proceedings to establish the real party in interest?
So the Rule 120 proceedings, again, were focused on the real party in interest of Fannie Mae. I'm certainly not intending to be inconsistent, but the question, as I understood it, is procedurally, when does it end? And I think procedurally it ends with an FED hearing, because you do have the opportunity to contest. I'm not arguing that the 105 was procedurally improper, only substantively meritless, if that clarifies the position.
Yes, thank you.
Again, I will ask that the order be affirmed and that my client be awarded its reasonable attorney's fees.
Mr. Fielder, you have just over 5 minutes.
Thank you. And after researching CRS Section 3838, 100, and 101, like many statutes, it takes a while to understand. There's cases to review. However, the policy is clear. There are a lot of foreclosures. They need to be handled expeditiously. We work under these presumptions, and then it's relatively easy for an attorney to review a document, to certify it, to file it in. I mean, all of Colorado law is not for the benefit of the qualified holder. It's just, it's perfect justice. If a person's in default on their mortgage, they need to be evicted. I'm sorry, but that's the bank's home, and I agree with all of that. However, the credit bid is the key. If you hold the note, and it can be a photocopy, I'm not saying you have to show me the note, all of that's frivolous. But if you're a qualified holder, you make your credit bid with that note. And so when the law by the legislature states that, and this is that 8C, an assignee or transferee shall be presumed to not be a qualified holder, that's to protect the integrity of the system. Because if you're not a qualified holder, you have to bring the original, and that's your money. That's your bid.
But didn't the Supreme Court essentially reject your argument in Amos versus Aspen Alps?
No, I think that was really a helpful case for me, because in the end, that was more about the Rule 120 and a person's ability to have a hearing and get a hearing and litigate some of these issues. But in the end, I don't think that case is dispositive with regard to the 101-8C issue. I think this is more or less an issue of first impression. And had it been cured immediately, because I did file an objection to approve the sale, and that's all part of our statutory construction. As soon as there was an assignment and sell, first of all, frankly, I believed that the real party in interest had poked their head out, because Fannie Mae was never the real party in interest. So I thought that proved my case. But if it was a valid assignment, so be it. You have to file the original or a certification, or without consideration, you're making a credit bid. So I think there's just a lack of standing to make a credit bid, a lack of standing for the public trustee to sell the property. And in that regard, I think de novo review could set aside the sell, but at a minimum, back to the district court so that we can have a 105 hearing. Thank you.
Thank you, Mr. Fielder. Thank you, Ms. Beckwith. Again, we appreciate your oral arguments. They'll be very helpful to us in deciding this case. The case will stand submitted and a written opinion will issue in due course. As I mentioned, at 9 o'clock, we have an oral argument scheduled for 10 o'clock, Bolton versus the Industrial Claim Appeals Office in the Cherry Creek School District. Are counsel here for that case?
Yes, Your Honor. Bernard Wilson on behalf of the Cherry Creek School.
Okay. So is your opposing?
Thank you. Good morning. May it please the court. My name is Penny Merkel. My registration number is 43618. I represent the injured worker, Jennifer Bolton, in her workers' compensation claim, and I would like to reserve 3 minutes for rebuttal, please.
Okay, I'll try and let you know when we get there.
Thank you.
Thanks.
The issues in this case are two mainly, whether the insurance company may terminate a previously admitted general award of medical maintenance benefits absent a petition to reopen under the Workers' Compensation Act. And secondly, whether the panel's determination that further treatment was rendered unnecessary by an intervening event, and whether that's supported by the record and the applicable law. In this case, the insurance company stipulated, and an order was entered that admitted for the general award of medical maintenance benefits. The insurer also filed a final admission of liability in this case, which admitted to the general award of medical maintenance care. A final admission of liability is a legal document that lists all of the benefits which have been paid or will be paid under the Workers' Compensation Act.
Ms. Merkel, in paragraph 4 of the stipulated motion, an agreement to resolve the PPD dispute, the stipulation says that respondent additionally agrees to file a final admission referencing this stipulation and resolution of the current claims for PPD and admitting for maintenance care through authorized providers that is reasonable, necessary, and related to this compensable injury. Doesn't that language put in play whether or not any particular item of maintenance care was reasonable, necessary, and related to this compensable injury?
Your Honor, that's exactly what it says, and I want to focus on a word that you said there, a particular maintenance medical care. Under the Grover and Snyder line of cases, respondents may always challenge any particular treatment on the basis that it is unrelated, unnecessary, or unreasonable. But that is not what happened in this case. What happened in this case is respondents presented at hearing to terminate the general award without denying one single maintenance care request before this hearing occurred.
So if the employer had filed 5 separate requests to terminate each, I don't remember how many different types of care the claimant was getting, but filed a separate motion to terminate each of those types of care, are you saying you wouldn't have any complaint here today?
That's correct, Your Honor. The respondents always retain the right to challenge a particular medical care at issue. So if a doctor, for example, prescribes a medication that respondents feel is unreasonable, unnecessary, or unrelated to the claim, they always retain the right to challenge that particular medication. What they don't retain the right to do is terminate an award of benefits that's been admitted in an order and by a final admission of liability without petitioning to reopen. They always can do that, but they have to file the jurisdictional prerequisite in order to get there.
Counsel, on the facts of this case, as I understand it, the admission as to the causation was to essentially a marginal increase in mental health issues, and the maintenance therefore. Mm-hmm. If the argument is because she's returned to the baseline, there's no longer a need for any maintenance, why do they have to go through, well, we challenged that particular drug, oh, and that drug, and that drug, and that drug, and that, and just instead of just saying, now that she's back to the baseline, there's no more need for maintenance?
That's an excellent question, Your Honor, and the answer lies in the statute under the reopening provisions at 843-303. So what we have is, first of all, a jurisdictional prerequisite. A petition to reopen must be filed in order to terminate that general award of medical maintenance benefits. But assuming, in this case, that the hearing application that they filed can be treated as such, we have an additional problem, and that problem arises under the City and County of Denver case. The reason is because, Your Honor, once a final admission of liability has been filed, the original initial causation determination has been finalized. It can no longer be challenged, okay? So after, if the respondent's hearing application is treated as a petition to reopen, they have to prove from the point in time that she was placed at MMI and going forward, her condition had substantially improved. in order to terminate that award of benefits. They cannot challenge the original causality determination, which was what happened at the ALJ level in this case. They said she never really had this problem, and so that was an improper analysis on the part of the ALJ.
But how is the phrase related to in paragraph 4 of the stipulation different from causation? I mean, if it's related to, that kind of sounds like causation, and if it's like causation, the stipulation specifically allowed that challenge.
So I grant you that this is a confusing and complicated issue, but it all is explained very well in the city and county and Denver, because first of all, respondents must establish grounds, change of condition, mistake, error, fraud, overpayment, in order to be granted the right to petition. Once they reach that barrier, then it's appropriate to terminate a general award of maintenance benefits. But that's not what happened here, and that wasn't the standard that was used. They just wanted to say this is no longer reasonable. This is no longer causally related. And had they established the jurisdictional change of condition requirements, that might have been appropriate. But what happened is they challenged the original causation determination. So she never had this problem in the first place. That was inappropriate in light of the final admission of liability being filed and the maximum medical improvement determination.
But even if you're right, and even if there's at least a hint of saying, well, there was never causation in the first instance, but isn't Judge Tao right that there was also a specific determination made that even if there had been causation initially, there no longer is? And isn't that squarely within the language of paragraph 4?
So, no, Your Honor, and the reason is because of the city and county of Denver analysis. So it's like looking at this causation through two different lenses, if you will. The claimant originally has the burden to prove causation in the first instance, okay? Once that final admission of liability was filed, that issue closed. Respondents admitted, we're responsible, okay? What happens when a petition to reopen is filed, it triggers a jurisdictional prerequisite. And what they have to establish is a change of condition. And that change of condition is viewed differently than it is causality in the first instance.
How so?
Because under City and County of Denver, the only evidence that can be used to support that change of condition is from post-MMI forward. They have to prove that her condition substantially improved from the time she was placed at MMI. Because at the time she was placed at MMI, general medical benefits were needed. And that's a different issue, and that was not what was litigated at the hearing.
But isn't that practically what the school district was doing, was saying that there was a change after MMI? In essence, weren't they arguing there was a change of condition even though they weren't proceeding under that statute?
Well, I think that's what they attempted to argue, Your Honor, but if you look at the order that the ALJ entered, she cited to no less than 15 medical records and opinions that were already in the hands of the insurance company at the time they filed the final admission of liability and entered into the stipulated agreement admitting that she needed maintenance care. And that's why. So yes, did they make that argument? Yes, but that's not the evidence that was relied upon. What was relied upon by the ALJ was all information that predated even her injury. And that's why this decision has to be reversed.
I'm trying to figure out what difference there would have been. I mean, if there had been a petition to reopen, as you say there had to have been, would the burden of proof have been different? I mean, what would have been different in terms of what was litigated as opposed to what was litigated?
So the burden of proof is the same, to answer your question. It's preponderance of evidence. But what's different is the issue. So the issue is, has her condition changed post-MMI to warrant a termination of benefits versus what was actually litigated, which was, did she ever have a psychological condition needing treatment in the first place? And that's what the difference was.
And you don't admit the possibility that, in essence, the ALJ decided both of those questions? In other words, that maybe improperly decided that the initial causation was not there, but also said, but even if it was, it's gone now.
So I don't think that is what she said, because if you look closely at her order, she cited to specific examples, one of which was claimant presented no evidence that her condition now was substantially different after the workplace injury occurred. That tells me that she's focusing all on her pre-existing conditions and not on how she was functioning at the time that she was placed at MMI. And we know how she was functioning when she was placed at maximum medical improvement because of the dime examiner's report. He said she's having tremendous psychological difficulty. We need to change her medications.
Counsel, doesn't the concept of maintenance benefits essentially mean there's nothing closed, so what needs to be reopened?
Okay, so I think that's an excellent question, and it's really confusing. I'm going to try to break it out as best I can. So they're two separate things, okay? When a final admission of liability is filed, benefits that are admitted, okay, are closed as long as there is no objection in writing from the claimant within 30 days, right? So what the final admission of liability does is establishes entitlement to benefits, okay? So that's a different question than whether or not medical benefits are open. So yes, medical benefits are open in this case because the final admission of liability established the right to those. And that right can only be challenged under a petition to reopen.
But they didn't challenge the right to the benefits. As I said at the beginning of this, my understanding is acknowledging that there's a baseline at the time of injury of mental health needs.
Mm-hmm.
They admitted that because of the injury, those needs spiked,
Mm-hmm.
and now they're saying it's no longer above that baseline, so there's no longer a need for maintenance benefits. But if maintenance benefits are always open, why would you need to reopen to readdress the maintenance benefits?
So you need to reopen if you want to terminate the maintenance benefits. You don't need to reopen if you want them to be open. Does that answer your question, Your Honor?
Excuse me, Ms. Merkel, you have about 2.5 minutes left.
Well, I want to make sure Judge Tao's question has been properly responded to.
You've answered my question.
All
Whether
right.
it was persuasive remains to be seen.
Thank you. I'll reserve the remainder of my time.
All right, thank you, Ms. Merkel.
Good morning, judges. My name is Bernard Wosner, and I represent the Cherry Creek School District with respect to this appeal of the ALJ's decision and the Industrial Claims Appeals Office affirmation to cease and end post-MMI benefits, also known as Grover, after the case by the Colorado Supreme Court. One of the issues here is whether or not there was substantial evidence to support the judge's findings to end post-MMI treatment. And under that review, this court has to grant deference to the findings of fact of the administrative law judge and is only reversible on clearly erroneous terms.
But Mr.
Here-
Welsner, my understanding is Ms. Merkel is not challenging whether there was sufficient evidence. She's making a legal challenge.
What I actually heard was a completely different hearing and understanding of what I was ruled at and argued by myself at this hearing, and that there was not any evidence to support ending MMI that existed after we had admitted the final admission liability and she placed MMI, and that's absolutely not true. In the record, the own treating physician, Dr. Koval, had stated that we had reached a point where her physical had plateaued. There's not going to be any more treatment for that. And then from the psychiatric standpoint, we had independent medical examiners and other experts that said that what Judge Tao had said is that the injury spiked the need for treatment, and then it came back to a baseline. And that evidence all existed after, and that they are challenging whether or not that evidence exists.
Well, my understanding was similar to Judge Taubman's. I mean, I think the argument pretty clearly is that the wrong mechanism was used by you to terminate these benefits, that you were required to move to reopen, and you didn't do that. And in fact, if you look at paragraph 6 of the stipulation, I think you could read that by saying that to the extent that there's any ambiguity here as to whether you can use this method or that method, paragraph 6 says, by this stipulation, the claimant does not waive any claim to medical maintenance benefits, and the parties reserve the right to reopen this claim in the future as permitted by law. In the event this claim is reopened, both parties are entitled to all claims and defenses. Doesn't that fully support the argument that you used the wrong procedural mechanism in this case?
I don't think so, Judge, and I think the reason why is because the nature of maintenance or post-MMI medical benefits are only provided to the claimant if they are reasonable, necessary, and related to the injury. And that is true no matter what stage of a workers' compensation you are at the workers' compensation claim. The admission of causation of an injury at any time in a case, the payment of any benefits, you do not waive or relinquish the ability to challenge whether or not medical treatment becomes necessary. And it's a different nature than the other benefits that are available under the Colorado Workers' Compensation Act.
But
Because you
again,
have-
she's not disputing that there is that question that can be asked. She's disputing whether you asked it in the proper format. And I would take it a step back. You started this suggesting that we have to defer to factual finding. Her assertion is that without a motion to reopen, there was a lack of jurisdiction, in which case, if true, we wouldn't defer to anything because there was action outside of the authority of the hearing officer.
And from a procedural standpoint, I think what they're saying when you're this requirement to add a petition to reopen is undermining the Colorado Supreme Court cases and progeny from Grover, which says that any time you can challenge the relatedness of medical. And it doesn't say you have to only challenge specific. It says any time you have that option to challenge whether medical treatment is related to under the Act. And there is nothing in the Act that says you have to seek a petition to reopen to challenge medical maintenance.
How much time elapsed between the execution of this stipulation and your request to terminate the maintenance benefits? I mean, it does seem to me, Mr. Wilsner, that it sure looks like an end run that you pulled around the stipulation that you entered into, and then very shortly after that, after entering voluntarily into this stipulation, you come into court and you say, oh, this stipulation doesn't mean anything.
Well, I would point out first that from the time of the admission, or from the time of maximum medical improvement, there were 19 months of post-MMI treatment that was provided here. And the stipulation, I don't have the date on the top of my head, but that stipulation occurred after there was MMI, and then there was a dispute about how much should be paid for permanent partial disability benefits. So we were providing post-MMI during that period of time. When we resolved that, we continued to provide post-MMI benefits for a long period of time, and then we sought a hearing to end those benefits when they were no longer related to that case. And so I don't see it as an end around of what happened under that stipulation. We did exactly what we said we would do under the stipulation. We admitted for post-MMI benefits and provided them for 19 months, and we provided ample benefits. I mean, we provided, the ATP provided, there was 4 different psychologists, there was psychiatric evaluation, there was mild traumatic brain injury evaluation by a separate physician. So we did not abdicate our responsibility or our agreement to provide those benefits.
Mr. Wilson, Ms. Merkel was suggesting to us that there is a significant difference between doing what the school district did here and just reopening medical benefits as opposed to filing a motion to reopen or a petition to reopen. In your view, is there any difference between those procedures?
Yes, and I think what Ms. Merkel is trying to impose is an extra level of proof that doesn't exist, that there has to be a petition to reopen to show a change in condition. And typically, a change in condition means something different under the law. A change in condition has been, under Chavez 714 P. 2nd 1328, is changing the condition of the original compensable injury or to a change in the claimant's physical or mental condition which can be causally connected to the original compensable injury. And that's not what is happening here. We're not arguing that there was a change in condition. We argued, and the judge found as fact, that this person had a change in condition because of an injury and then had returned to baseline, and we provided maintenance that maintained that position. And to impose another requirement that we have to have a change in condition here would be contrary to the law of Grover and the Colorado Workers' Compensation Act, that respondents only have to provide reasonable, necessary, and related benefits. So I think that's the problem with her analysis, is that what happens when you have a admission for maintenance treatment, and you should know under Colorado Workers' Compensation law, the respondents are not allowed to put in their admission that we only admit for physical therapy for 2 years, or we only admit for chiropractic care. The only thing you're allowed to do is say, generally, we will provide medical treatment to post-MMI that's reasonable, necessary, and related to the injury. So in those circumstances, we're not saying that this admission was wrong or changed. We provided that. We're just saying the responsibility is over because it's no longer causally related to the injury. And that's not a reopening or a change in condition. And I think just to continue, that if we had admitted for permanent total disability benefits, which is lifetime of wage replacement benefits, and then the person got better and was able to go back to work, we would have to show that change in condition. And that's a specific type of benefit. But that's not what happens with post-MMI benefits under the law as it's been established by the Colorado Supreme Court. You only admit for what's reasonable, necessary, and related, and that is what was adjudicated, and that's what that's what was admitted, that's what's going on here.
The ALJ seemed to go out of her way to talk about the underreporting by Ms. Bolton that occurred before this stipulation had been entered, before the admission of liability had been entered. What possible relevance would there be to a termination when you sought it, to whether or not she had previously unreported, whether she previously had been honest with the treating physicians? That kind of threw me.
I think it simply is a matter of where are we in the timeline of her psychiatric condition. She was here before the injury did this, and it comes back down here. The underreporting was to explain that the medical doctors may not have understood during this whole process that she actually had pre-existing depression and psychiatric disorders, and now we've returned to that baseline. I don't know, does that help answer your question? I don't think that the emphasis was anything more than here's an explanation of why we're now where we were before the injury. I think it's as simple as that. Some of the points that I'd like to make about some of the case law that we have cited in the case is the Industrial Claims Appeals Panel in Arguello versus State of Colorado had already addressed this issue where a case that was in the same procedural status where there was a final admission of liability and the respondents were seeking to deny all post-MMI care, the claimant specifically argued that the respondent should not be permitted to proceed on the issue because it failed to file a petition to reopen. And the Arguello and the Industrial Claims Appeals Panel rejected that, saying that that's not what has to happen in Grover. You do not have to seek a petition to reopen to contest general admission or the final admission and a general admission for ongoing post-MMI benefits.
Isn't there language in Grover that suggests otherwise, though?
And I don't think so. I think Grover says that you have two opportunities. And this is kind of echoes what's happened and exactly what was said in the stipulation. For Grover, the Court of Appeals stated,
Well, I'm talking about the Supreme Court.
yes,
And what the Supreme Court said at page 712 is, at the time a final award is entered, available medical information may be inadequate, the diagnosis may be incorrect, or a worker may experience an unexpected and unforeseeable change in condition subsequent to the entry of a final award. When such circumstances occur, Section 853.113 provides recourse to both the injured worker and the employer by giving either party the opportunity to file a petition to reopen the award. Didn't the Supreme Court directly address this situation?
I think they said that that is one avenue for which respondents can challenge and reopen an award of benefits. But they also said in their decision that the employer may, of course, contest any future claims for medical treatment on the basis that such treatment is unrelated to industrial injury or occupational disease, period. And then in their holding, they said, in addition, the employer retains the right to file a petition to reopen. Here, we don't have a circumstance where you need to petition to reopen. We just have a circumstance where the substantial evidence says that this treatment is no longer related to the industrial injury, and the Colorado Workers' Compensation Act says treatment that's not related to the injury. So I think the Court of Appeals, the Colorado Supreme Court and Grover, Grover is very important because that's the case that set up how post-MMI benefits exist here. The Grover case and its progeny have said you can't have a specific order of post-MMI benefits. It can only be a general order of post-MMI benefits. You can only have a general admission that says you're going to allow post-MMI benefits. They've even just changed the form. That's all you can say, is that you're going to have post-MMI benefits. What you can do is say, we're only going to provide them if they're reasonable, necessary, and related, and have that challenge. And that's what the respondents did here. And it's the respondents' position that the Industrial Claims Appeals Office and the ALJ's order should be affirmed. Thank you. Unless there's any other questions.
Thank you, Mr. Wosner.
So, Your Honors, I would like to just readdress my response to Judge Tao's question. And I want to think about it in this way, as an example, a hypothetical example. If an injured worker's claim had closed by a final admission of liability without a general award of medical maintenance benefits, then she later needed treatment for that workplace injury, she would be required to file a petition to reopen and prove a change of condition had occurred since she was placed at MMI and that denial of benefits was closed. In the same way, if the insurer wishes to terminate a general award of maintenance benefits, they must prove that the claimant's condition has improved substantially since being placed at MMI before they can terminate that medical maintenance care. In this case, those grounds were not established.
But isn't that inconsistent? I mean, I previously read a portion of Grover, but another portion of Grover that your opponent is relying upon seems to say exactly the opposite. Seems to say that there are two ways to go, and they chose the way they chose. And
So
Grover seems to say that's okay.
I think there are two ways, Your Honor. So The two ways are this: they can either challenge a particular treatment, or they can file a petition to reopen. And those are the two ways that are promulgated by Grover, and then the following Snyder case that also analyzed that issue. The last thing I just wanted to mention is, in my reading of the answer, there was no binding legal precedent cited by the insurance company in this case. But one of the cases that they did cite, I think it's really important to pay special attention to, and that was Barker v. Pooter School District. That line of cases that insurance counsel just cited to all stems from that Barker case. And in Barker, the respondents requested a petition to reopen and asked the court to terminate a general award of medical maintenance care. And the ALJ in that case properly put the burden on the insurer and ultimately found that they failed to meet their burden of proof to establish the grounds to reopen. The respondents in that case remained responsible for the maintenance medical benefits, but also free to challenge any particular treatment. Okay?
Ms. Merkel, your time is up.
Oh, thank you, Your Honor.
Thank you, Ms. Merkel. Thank you, Mr. Wilson. We very much appreciate your excellent arguments in this case. The case will stand submitted, and a written opinion will issue in due course. That concludes the oral arguments today for Division 1. The court will be in recess, and the bailiff may so announce.